Before a single ruling is made, this courtroom is already sitting on a powder keg. We're dealing with a defendant who isn't new to the system, isn't new to substance abuse, and definitely isn't new to operating while intoxicated charges. This case isn't just about one failed drug test, it's about patterns, public safety, and whether the court can trust this individual to stay out of trouble while awaiting trial. The tension you're about to hear comes from one core question. Is this a technical violation or a serious warning sign? On one side, the defense argues timing, claiming the substances may have been used before bond conditions officially kicked in. On the other, the prosecution is laser-focused on history, multiple OWEs, prior convictions, and a defendant who keeps testing positive despite knowing what's at stake. As this hearing unfolds, listen closely to how the judge weighs legal technicalities against real-world danger, because by the end of this exchange, the court will have to decide freedom with conditions, or a much harder line in the name of public safety.
Make this not a bond violation. I think if he would have used on August 30th or the 31st.
But if this is a 5 and this is showing up in his system at all, I would consider him a danger to the public and that his bond is inappropriately set. So I'll let you make your argument. But
Can I have just a second, Your Honor?
sure.
So, yeah, I just think there's possibilities that he's not used after being arrested. And those,
What?
cocaine could stay in his system for up to a week if there's heavy use. So the failure.
Let's say, I don't know, a week, but let's say I agree with you regarding that. Then his bond, and this is what I'm saying to you, then his bond on these operating while intoxicated, since I have 2 in front of me and there's another one in Wayne County, then I think that his bond in these cases is inappropriately set. And what I mean by that is that I clearly have these 2 cases. There's the other one in Wayne County. He's got priors and he's still using.
This is where things get legally interesting. The prosecution is walking a careful line here, acknowledging the science behind drug detection while still hammering home the bigger picture. THC can linger, cocaine might last longer with heavy use, but the judge isn't just focused on chemistry. What's really driving concern is context. This isn't a first offense. These aren't isolated mistakes. We're talking about 4th and 5th OWI level behavior with another case pending in another county. Even if the defense can argue that the test doesn't conclusively prove use while on bond, the court still has discretion to ask a broader question. Is the current bond protecting the public? And that's a powerful shift. Once the conversation moves from did he technically violate to is this bond appropriate at all, the defendant's past suddenly becomes the loudest voice in the room.
I agree with you regarding that. Then his bond, and this is what I'm saying to you, then his bond on these operating while intoxicated, since I have 2 in front of me and there's another one in Wayne County, then I think that his bond in these cases is inappropriately set. And what I mean by that is that I clearly have these 2 cases. There's the other one in Wayne County. He's got priors and he's still using.
I think I'm fine. I think that's all factually true, Your Honor. Or he's at least not passing the test. Would the court be willing to have him test today?
Would he come back clean?
Yes, sir.
But here's again my problem, counsel. My problem is really the danger to the community. Because I have an incident that occurred in February of 23. This other one occurred in July of 2023 or 23. He's got a pending Wayne County one. He's got prior ones and he's still using. So I don't know that he should be out because at some point luck's going to run out. He's going to get behind the wheel and he's going to take somebody out.
I don't have a vehicle. Your Honor, I don't believe he's driving. The test certainly indicates use. Look, drunk driving is absolutely dangerous, but there's no dispute. I think if he's using drugs in his own home, I don't believe that's a danger to the community that rises to the level of him needing to be incarcerated. I think he can remain out if he fails a test. that would be a bond violation at this point because he has been on bond since.
This moment captures the judge's real fear, and it's not abstract. The concern isn't paperwork or procedure. It's the image of a repeat offender eventually getting behind the wheel again, and someone innocent paying the price.
Well,
the judge says, at some point luck's going to run out. That's not legal language, that's human language. The defense pushes back by separating drug use from driving, arguing that using substances at home doesn't endanger the community, but the court isn't convinced that those lines stay clean forever. History suggests otherwise, and that's what makes this exchange so tense. The defense is arguing potential, while the judge is weighing probability. Ask yourself if someone has crossed this line before. How many chances should the system give before stepping in?
Him failing those tests, and we don't have a pattern or anything like that. You know, we don't know if this is a one-time slip-up. We don't know if he's used while he was on bond. I think the court could allow him to test today, and that would solve the problem.
May I respond?
Right.
I would wholeheartedly disagree that there's no pattern. I think that the defendant having 3 previous convictions for OWI in 2002, 2004, and 2016, a 2023 Wayne County case, a 2023 Washtenaw County case, and a 2024 Washtenaw County case is absolutely a pattern. Furthermore, Your Honor, in this matter, if I recall correctly, and I think I do, but I will make sure, I believe his BAC was incredibly high. And I'm going to double check that before I give that search to the court. But if I recall correctly, I think in both cases, his blood alcohol content was above a 0.3.
That's correct, Your Honor.
So we are not, if this isn't a pattern, I don't know what a pattern is. People would request that the court find that the bond is an abuse of discretion and set a higher bond and remand.
I just don't think the circumstances have changed since the bond was set because and I know the court could disagree, but we don't believe there's evidence he's used since the bond was set by the magistrate, at least conclusive evidence. There, you know, it's up in the air as far as he failed the test.
You keep arguing the use. The argument is, even if I give you that, the argument is I don't know that he should be out. Any use, given his record.
This is the turning point. The prosecution dismantles the idea that this is a one-off slip by laying out a timeline that stretches back decades. OW is in 2002, 2004, 2004, 2016, then again in 2023 and 2024. Topped off with extremely high blood alcohol content levels. That's not coincidence. That's repetition. And in courtroom logic, repetition equals predictability. When the judge agrees that if this isn't a pattern, nothing is, the defense loses critical ground. At this stage, the argument shifts from, has he proven danger, to, has he proven he can be trusted? And with every prior conviction named out loud, that trust erodes just a little more. This is where past decisions catch up, and where leniency becomes harder to justify.
Can't really deny it, but what we can say is he's not driving far. So the extreme danger to the community that comes with intoxicated driving is not present. Obviously, there's some danger to the community in hard drug use, but I believe it's less. I believe it can be managed with restrictions such as continued testing. If he fails again, you know, he's obviously used while on bond. The court could do that. I think the court could order increased testing. You could put him on 3 times a week. I think he was on 1 time a week. I mean, the court could order testing every day if the court felt that necessary. There's a lot of options other than just incarcerating him.
What did you wish these set for?
I'm sorry?
What did you wish these set for? Preliminary examination?
No, he's going to waive.
He's waiving. All right. So at this point, what I will do is his bond is going to be changed. I'm going to set it at $25,000 cash or surety. So you're waiving your right to preliminary examination in these cases? Yes, sir. You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense is alleged.
Here's what the defense is really asking for. More supervision instead of incarceration. Increased testing. More restrictions. Tighter monitoring. And legally, those are valid alternatives. The court does have options short of jail, but the judge has to balance flexibility with credibility. If someone continues to test positive even under supervision, does increasing oversight actually solve the problem, or just delay the inevitable? This discussion highlights an important truth about bond decisions. They're not rewards, they're risk assessments. The court isn't punishing future behavior, it's trying to prevent it. And when a defendant is already on what amounts to a personal recognizance bond, the tolerance for further risk drops dramatically.
25,000 on PRs, but
I have on each of these that they're PR.
Oh, I apologize, Eric, my mistake. Thank you.
So people do waive
We do.
preliminary examination, haven't been waived, defendants bound over to circuit court on the single count in each case.
We will stand mute, waive the formal reading.
Defendant having waived formal reading, standing mute, court will enter not guilty plea pre-trial. Custody pre-trial date.
September 24th at 1:30 with good time.
September 24th, 2025, 1:30 before Judge Conlon in each of these matters. The bond, as indicated, is set in each case. It will be changed from a personal recognizance to a $25,000 cash or surety. Defendant is remanded. Yes, you may.
In the end, the court draws a clear line. The defendant waives his preliminary examination, and the case moves forward to circuit court, but not without consequences. The bond is increased to $25,000 cash or surety, signaling that the judge no longer believes a simple promise to behave is enough. This ruling reflects the court's core responsibility, protecting the public while ensuring due process. The takeaway here is powerful, even when technical arguments exist. Long-term patterns and public safety concerns can outweigh them. This case is a reminder that bond conditions aren't permanent, and trust must be maintained, not assumed. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.